Court calls the case, People versus Robert Lewis. Go ahead.
Under Natalie Pate for Mr. Lewis. Please state your name for record, sir.
Robert Andrew Lewis.
All right, go ahead.
Your Honor, day and time set for sentencing. I have discussed this matter yesterday. I have reviewed the SIR rather first with Mr. Lewis. We have no changes or corrections or deletions. As to the recommendation, I do ask you to briefly address that before sentencing.
All right, go ahead.
Thank you, Your Honor. I have discussed both with Ms. Valera and Ms. Barroso yesterday. The recommendation was originally for 93 days in jail, credit for 70. I won't pontificate for all the reasons for that because I believe Ms. Valera has no objection to our request is to have Mr. Lewis sentenced to 70 days, credit 70 served, no objection to the rest of the recommendation.
Why would I do that?
Mr. Lewis recently pled to all his
Well, why wouldn't I just suspend the balance as opposed to have him serve the balance?
We have no objection to the rest of the balance just being suspended.
Okay. Mr. Lewis, anything you want to say? Did he mean that? I know he did. All right. I'll sentence him to $125 statutory fee, $175 restitution to Ashley Lotus, payable through the court. How long is it going to take you to get that in, young man, if you get released? Is this the only thing holding him? Or?
Your Honor, if I may, he does have a whole bit of time that he needs to sign his extradition waiver for. So we do not know how long we'll be in that custody. He does have sentencing at circuit court scheduled on August 7th. All that being said, I would request that fines and costs be paid.
Let's do it this way. You just waived extradition to go to Ohio. Is that right? So what I'll do, I don't know what's going to happen down there. I'll just make this payable by December 31st, 2024 to give it a day. So, and then I'll order 93 days jail, credit 70, serve, the balance is suspended.
Thank you, Your Honor.
Thank you. Good luck to you, young man.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case, People versus Robert Fritz.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Fritz. I don't believe Mr. Fritz is pregnant. I don't have an explanation for it, so if you're here today, I would ask for it.
Please declare on behalf of probation, Your Honor, Mr. Fritz is scheduled for the court violation of probation hearing. He's not compliant with all terms ordered by the court. It was a jail recommendation today. Probation without the court issue.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $15,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court calls case, People versus Thomas Martinez. Court does call the case, People versus Andre Gibson.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Gibson. Your Honor, I do not believe Mr. Gibson is present.
But if you said it slow enough, he would show up. Or no, go ahead, sir.
I do not have an explanation for his failure. Your Honor, I would ask for it.
Please declare on behalf of probation, Your Honor, given Mr. Gibson's appearance today and does not comply with probation back.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $15,000. I'll give a 10% privilege. That warrant will issue immediately. Court calls case, People versus Thomas Martinez.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Martinez. Mr. Martinez, please state your name.
Thomas Martinez. Thank you.
Your Honor, we did review the pre-sentence report. We didn't have any changes to that report. As for the sentence recommendation, we don't necessarily have any objections to the recommendation. We do ask, though, that the court allow him to be released in treatment. He is serving a sentence on a 14B case, but in that case, Judge Washington ordered that he can be released to treatment on that one if he completes the in-jail bar program, which he's set to finish next week. After that's up, he can be released on that case to treatment. At this time, that's the only other case that's holding him in jail, along with this one. So we'd be hoping that he'd be allowed to be released on this one as well, if the jail can find him.
Sir, is there anything you want to say before I impose sentence? Sentence of the court, I'll order $125 statutory fees, the state minimums. I'll order 120 days in jail credit for the 46 that you've served. The balance is suspended. I will also indicate defendant may be released to inpatient treatment after completion of bond trial.
Thank you. I am getting this court question. Stay home. My family is taking care of it.
Okay, all right, very good. Thank you. Yes. Yes, we do.
Assistant Prosecuting Attorney Morgan Burrows on behalf of the people waive the potential conflict between this honorable court and the public defender's office. The people do not believe that that's the reason they display their avoidance of it down.
Good afternoon, Assistant Public Defender Laura Parody. The Public Defender's Office likewise does not believe the conflict exists, but if what does, we do something.
All right. And the court, for its part, also does not believe that there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. I'm out.
Yes, sir.
Court does call the case of the people of the state of Michigan versus Alexis Naveen.
Prosecuting Attorney Morgan Burrows on behalf of the people.
Good afternoon, Assistant Public Defender Laura Parody on behalf of Ms. Lee. Thank you, state your name, please.
Sally.
All right. This is your motion regarding release.
Yes, Your Honor.
Go ahead.
I would rely on the writing. We have had an off the record conversation. I have got some more information from my client that I would like to provide. Her plan, if she were to be released today, is actually to turn herself into the emergency room or report to the emergency room. She plans on going to St. Joe. Because what I've written and explained to the court, she believes her body is in a PTSD cycle, essentially, and which has affected her nervous system. She wants to go to the emergency room in inpatient psych situations so she can stable her nervous system immediately from if she were to be released. She wants to go to St. Joe to stabilize her nervous system because of the PTSD that she's been diagnosed with and has been suffering ramifications of while in custody. When she'd be released from the hospital, she does plan on returning to the hotel that she was staying at previously. Her belongings are there, and they are holding her belongings there. She is able to pay for that hotel with both personal funds and insurance claim funds from USAA. There was another house that was not the house that is the marital home that flooded. The family does not stay there. It is only in my client's name. That house flooded, and my client filed a USAA claim, not with the VA as I previously understood, but with her insurance company. She has not received those funds because she did have someplace else to stay, which was the marital home. She now, according to the court orders, cannot return to that home, so can contact her insurance agent and have access to those funds. And she also can pay for a hotel to comply with the court's orders from her personal funds as well, as a backup. So that is the plan if she were to be released today. And I have explained to her the importance of following court's orders. Make sure that everyone's safe in this case.
Okay. Let me stop you, and I'm going to have some other questions, but as we were in chambers talking, one of the things that the court had indicated, and I think I had indicated in a previous proceeding, was regarding a tether. difficulty is gonna be is that if she goes to the hospital,
She they might have to take that tether off. My thought would be if she were to go to the hospital, report to community corrections when she's released and stabilized to get placed up on tether.
because I'm not saying no just to make it difficult. I'm saying no because we had a very quick violation of the bond conditions. Because of the circumstances of this defendant, I'm considering release under a very sort of stringent criteria, keeping it on a short lease, making sure that we're looking at it. But one of those criteria was the tether. Now, I understand that while we were talking, I think you just got this information about going to St. Joe's or the Trinity. And that complicates the issue regarding the tether.
She says she can report, she can go to the place with the tether, go to the hotel. Her medication is there. We did discuss reporting to the VA to get those extra services in Chambers, and she's very willing immediately to contact the VA to get that extra support. So if the court's on, I see the court's point. If the court's unwilling to release her, if she were to report to the hospital, if she were to be released, go to the hotel, get her medication, get stabilized, and report to the VA or engage the service of the VA as soon as possible. With the social worker contact that I have, that I can provide her the number as soon as possible.
Ms. Barroso.
Your Honor, if the defendant's needing some sort of inpatient stabilization, I have no issue with her being released for an inpatient time period, but I think that would need to be the purpose for her release as opposed to a release for all of these other things. And I would like to have an inpatient location identified and secured prior to release. I think my concern mirrors what the court's concern is getting her there and what happens immediately afterward.
Well, and I don't, while the defendant has a plan, I don't know that she goes to Trinity. I don't know that they're going to keep her. I mean, she's indicating this is what I want to have happen, but the moment she gets there, and if the medical professionals decide no, then what?
If no, she would go to the hotel where she's staying and contact the VA for the additional services that they are willing to provide her.
But the question becomes, if she's on a tether, is all of that going to happen? Because if I say she gets released, tether prior to release, so they get her out, they're on tether, she goes to the hospital, they take the tether out. They're trying to make an assessment then as to whether or not they're going to keep her someplace inpatient or what they're going to do. The tether comes off, potentially. Then they make the decision, she's not there, we have a problem.
I don't know, and to be honest with you, I don't know if the hospital would, I can't say if the hospital would take the tether off or no.
I know, and
They may keep it on, they may take it on, I don't know. I think all,
I think it depends, at least, I may be wrong on this, but I think it's gonna depend upon what kind of testing they would do. I mean, some of certainly their diagnostic tools, she can't have that on.
and maybe the extended services that she needs after.
Right. I mean,
I think my thought is just if they were to take the tether off or something happened to tether, this court could order her to immediately get in touch with defense counsel, get in touch with community service or community corrections, or tether agent. If that were to happen. At this point, we don't know. The other option, I think, is to order her to just get the tether, go to the hotel, get her medication, be
Well,
in touch with
can I ask why wouldn't you obtain services from the VA hospital as opposed to Trinity?
Would you like me to answer your?
Sure.
So I would like to go to Trinity to, I'm a trauma therapist. So PTSD is actually a central nervous system issue and a brain issue connect. So every door that's slammed, every key that I hear is like a pulse to my body. It's like a pound, right? Because my nervous system, when I hear it, my nervous system will jerk. I've tried to use all of the skills that I know as a therapist to stabilize myself. I can't stabilize myself. I don't have medication. And so I was going to go to the emergency room asking for my medication there. I don't anticipate that they're going to need to take my tether off. I would like an IV. I would like some medication. It would just be faster if I went to the emergency room. I did not anticipate at all that I would need treatment where a tether would need to be released. Then I would follow up with PTSD clinic at the VA. But what I'm seeking is that initial care that will make it easier for me and faster, that I am fully capable. It just takes me a little longer. I'm fully capable of being able to stabilize myself, which is why I've done so. It doesn't look like I've done well, but I've actually done very well here because I do have those skills. And if I have the medication and have the skills, I'm able to do that at the hotel. I will not go anywhere near anyone. I will take care of myself. That's my priority. I'm fully able to do it with other. I can do it at the hospital. I will make it.
She's residing where?
If she were to be released, she would be at the Holiday Inn Express on Research. I could provide the court with the exact address if you'd like.
That's what.
I'm sorry, I didn't hear you.
No, we can get that information. So I'm just posing hypotheticals to try to come up with something, but if she's released on a tether, goes to Trinity, and let's say they're going to keep her for whatever the reason, how are we going to know?
Well, if the court orders GPS tracking, we know she would be there.
They take it off, then no, we wouldn't know.
Right, if she was there and that was the last place, we may be able to assume that that's what happened. And my office can of course follow up with, we have a release of information for my client, so we can of course follow up with the hospital to follow her treatment plan. If what was recommended by the doctors. My client saying that she wouldn't, if she were in the hospital, they wanted to cut it off, she would tell them that if not, I suppose she could leave the hospital against doctor's orders if they wanted to.
Okay, so, and here's part of the problem. Part of the problem is I might be able to sort of launch out and say, I'm going to go out on a limb and trust this individual to do that. The problem is I already have a bond violation. And so it becomes a bit difficult to say on the defendant's word that she'll do this when that's what happened before. And it didn't work.
I think, as I've stated previously, I understand, there's this bond violation. At this point, I'm worried about my client's well-being, and that's why I filed the motion. And I appreciate the court working with us to try to fashion something. But at this point, I think I've met with her multiple times. I'm worried about her. I want her to get out, be stable. And all we can do is say she's learned from this experience, and that she won't do it again. With the extra support of my office. I mean, when she was arraigned and released, we had not even connected because, as the court knows, it was so quick. The bond violation. We now have a relationship. She has a relationship with our office. I've reached out on her behalf to the VA, and they know about her situation. I think at this point there's even more.
Yeah, and I hear you, but even in that short little window, I don't have all of the services of the VA in place either, because those have to take place at a certain point, which we were doing, and she's, I understand, agreed to place a certain structure around what's happened. Ms. Barosa.
At this point, I am also concerned about the victim's well-being. So it's not just the defendant's well-being that's in question here, but we didn't receive an answer as to why she wasn't going to go to the VA as opposed to St. Joe's. I don't know why she would not go there. She said she has meds at the hotel. So if this is really just about efficiency, she can go to the hotel where they're holding her belongings. But I think based off of all of this, we've had a lot of shifting. I will. She's set to appear on Monday. Why don't we keep her until Monday and see if we can get a bed at an inpatient location, if that's what she needs, or at least get something more structured in place until Monday or by Monday, because at this point, it doesn't sound like there's plans in place to provide the necessary security to ensure that there's not going to be another bond violation and that the defendant is going to have the supports that she needs to be able to succeed when she's out of custody.
I disagree. I think we presented the court with two plans as for next steps. She gets the tether, she reports to the hospital, gets the services that she needs. The hope, right, is that she keeps the tether on. The other option is she goes to the hotel, stays in touch with our office, stays in touch with, or gets in touch with the VA as quickly as possible.
Well, but okay, so here's the problem. The difficulty that I'm having with all of this is we were in the back for an hour or whatever, and we're fashioning something to effectuate a release, but do it in a manner that certainly the court is comfortable with in terms of doing it. And I think we have something in place because certain things are going to happen in sequence. We'll know everything. And then I come out, and I'm not necessarily blaming anybody, but then the plans have changed. And I'm still curious as to why all their services set up through VA for this individual. So I'm curious as to why there is this desire to go to Trinity prior to the VA. I mean, I'm not understanding that.
I think this information and this plan was what she provided me in lockup. She's willing to go with the original plan of what we were discussing in chambers. I think where it comes to Trinity, I can't want to speak to why Trinity versus the VA. I don't know. So if the court would like an answer to that.
I mean, I'll hear from her, but go ahead.
Thank you, Your Honor. I was actually trying to go a step further to take care of myself as opposed to just going, I am happy to go to the hotel. I can do that. I did not know that was, he had not met yet. That was what we had discussed. And I thought, okay, well, I'll go to the hospital first. And the reason I say St. Joe's is because they're a little more kind and compassionate than the VA, and because I know what I was seeking, the service I was seeking. I was just seeking hydration. I was seeking medication. I can hydrate, I can medicate, I can Pedialyte, I can care for myself just as well at the hotel. It might take me 3 days as opposed to 24 hours, but that is not an issue whatsoever. And I apologize that I apologize if it seems like I'm trying to change the plan or I'm trying to get Joe and not the VA. That wasn't the intention. They're just nicer and they're a little more kinder at St. Joe as opposed to the VA. I am happy. I am 100%. I will go to the hotel. I will stabilize myself and I will reach out to the VA as soon as possible. I'm not trying by any means, or I'm not trying to manipulate. And the truth is, my safety is important. I agree with the prosecutor. So my family safety is actually, and that is more important. And I will not ever, to the best of my ability, ever, put my family to care for. I will not do that. And I know that's coming. I apologize.
Ms. Perny, your understanding of the initial contact with VA, right? That initial contact that you would make would be via phone.
I don't think I understand your question completely. To clarify, I've spoken with the social worker at the VA. She said that Ms. Naveen can call as soon as she's released directly to her number, the contact that I've had.
And that's the process, and I may have said it inartfully, but that's the process that begins to set up what we're hoping is a more structured type of.
Correct. They will do a analysis of her needs and connect her with any more supports that they deem are necessary.
So, ma'am, I guess I'll start here. The first thing you need to understand is there's to be no contact with them. You understand that? All right. That just cannot happen. And if it does, I'm just as fair warning to you, if it does, then what's going to happen, you're going to be back in Washington County Jail, and counsel can file whatever motions they want to file. I'm not going to hear it again. Am I understood? And when I say that, no contact, I mean no contact through third parties. You understand that? No phone contact, no social media, nothing along those lines in terms of contacting the victim in this case. Understood? All right. Now, the other part of it is, and I think I'm going to do it this way because I don't want the plan to, whatever plan it is, to fluctuate. I mean, I think everybody here is trying to do what we can, and ultimately it falls to my shoulders to try to make sure that we can have the opportunity to get things in place. Part of the problem is that certain services that might be available to her through the VA aren't going to happen while she's here in custody. So I want to see the defendant get those, at least begin that process of getting those services. At the same time, I am not, by any stretch of the imagination, which is the reason that you're incarcerated now, I'm not going to tolerate contact. So Here's what I think I'm going to do, because we're set for Monday for a pretrial and a sentencing on the bond violation on Monday. I'm going to release the defendant on a PR after but she has to be placed with a GPS tether prior to release. The initial phase of that GPS tether will be home confinement to the Holiday Inn Express. She can then begin the process of contacting the social worker to begin to do that. I will permit, even though it's home confinement, that the defendant may travel to appointments with the VA. So if they can start something up, like if she calls once she's out, they can start something up, she can go. Right? But then she immediately needs to come back to the tethered location. Okay, so, and Ms. Levine, so that you also understand, I understand the issue regarding compassion, your perception of that. I don't know that for sure, but okay, I get that. But that part of it's not happening. Understood? So when you get that tether, you got to head to that address. If you don't, I'm going to revoke the tether. You're going to be right back in. If you decide to try to maneuver or change something within this, you're going to be right back. So one of the things I'm going to suggest to you is, if you're thinking about making a move and doing something, that you get in touch with Ms. Perrone, that you get in touch with your attorneys before you make that decision. Am I understood? So when you get that tether, it's home confinement, that's where you go. You make the call to the social worker at the VA, start that process along the lines. If they can get that moving, you're permitted to go to those appointments, but they've got to be documented that you have those appointments. I will, Ms. Perrone, then I will then reevaluate this on Monday, but at least this begins the process, and maybe we'll have some additional information about the structure. And I do that on Monday when she appears for a pretrial.
Great.
Okay. Anything further?
Nothing further.
All right. And Ms. Perrone, if you could get from your client the full address of where she'll be staying, including a suite or room number.
Sure,
Okay, I just don't want to put it on the record.
sure.
Okay.
And then I should provide that to the tether agent or this, or both?
Provide it to the tether agent. Actually, yes, provide it to the tether agent. Court calls case of the People versus Marquita Simmons. She's on.
Thank you. Under Natalie Pate for Mrs. Simmons, who should be present via Zoom.
Looks like she is. Can you state your name, please?
Marquita Simmons, sir.
Clear on the proper probation. Your Honor, Ms. Simmons is before the court for a violation of probation hearing. She is at her 2-year max of probation term. She owes a balance of $3,775. She's made no payments towards for fines and costs and/or restitution. She's failed to report to probation as directed. Failed to complete the theft class. Failed to complete her 25 hours of community service. Failed to complete or submit her fingerprints. She also failed the bench warrant out of the 15th District Court. Given all of the violations in this case, probation is asking that she be remanded for 365 days in jail, that she complete the in-jail MRT program, with the court to consider an early release upon completion of that program, waive remaining terms, accepting the financial obligation, and discharge from probation.
Thank you, Your Honor. Did have the opportunity to discuss this with Ms. Simmons on a few occasions. We did discuss both the alleged violations as well as the recommendation. Ms. Simmons does acknowledge and admit that she has violated probation in those alleged ways. However, as to the recommendation, she represented to me that she is a single mother to a 4-year-old nonverbal autistic daughter. And very unfortunately, she did struggle with homelessness starting in December of last year, last month. She was able to get into state housing in Flint. We are respectfully requesting the court to consider discharging Ms. Simmons from probation without improvement, but in ordering the restitution, of course, or continuing that order, but we are asking the court to consider not remanding her at this time. Ms. Simmons does acknowledge and take responsibility for the violations, but she is very concerned that if she was remanded, certainly to serve a year in jail, that her 4-year-old daughter would have, frankly, nowhere to go, and she has nowhere else that would care for her, and that we would respectfully request the court to not remand her or order any jail time, but to just simply discharge her from probation without improvement.
But she's done nothing.
And Your Honor, I would also like to state, this case started as a felony. I mean, the court is aware that it was reduced down to a misdemeanor. And she's made no effort to get any of the things done. I do know that she had some communications with my office indicating that she was never told, which they
Never told what?
that there was many attempts made by my office to get her back into compliance and or reach out to her. The only time that probation started with any consistency was yesterday before court.
No, excuse me, Judge, may I speak, please?
Yes, go ahead.
I never even met Miss Ellen. After the court date and all the appearances and things like that, I tried to contact her to see what the stipulations of my probation was. She never contacted me.
Hold on. You're telling me you tried to contact my probation office and they didn't call you back?
Yes, sir. I
I do
emailed.
not believe that. I don't believe that for a minute.
Yes, sir. I don't have no reason to lie on this lady or myself, sir. I did report where I was supposed to, and I contacted her, and I talked to the secretary lady. A lot of times she was always in court, and she said she'll give her the message to call me
Ms.
back.
Polera is only in court with me 2 days a week max. So that I know that's not true.
I don't have to lie to you,
If you
sir.
want me to go pull the phone logs, we can tell exactly when you may have called. What dates did you call?
It's been a long time. It's been over a year since I've called. That's been a long time. It's been over a year.
Your Honor, I can tell you, I've received a total of 3 report forms from her in the 2 years.
Three report forms.
3. A total of 3 in the 2 years. I had a phone conversation.
Well, just so the record's clear, that's a monthly reporting form.
Correct.
So if my math's correct, 2 years is 24 and only received 3.
Correct.
So we're about 21 short. Go ahead, Ms. Polera. I'm sorry.
I also spoke with her directly on March 20th. The violation of probation hearing was set then. When I spoke with her on that date, all I got was a lot of, I'm not going to do that and I can't do that. And I advised her that this court date.
I don't have the finances, and I kept telling
give her
you.
some time to get things completed, and she's done nothing.
I don't have the finances. If you're taking care of a 4-year-old autistic child, what finances do you have? I don't have the finances to pay for restitution. I've been said this in court a long time ago.
You had a felony that got reduced to a misdemeanor. You took the misdemeanor, got placed on probation for the longest you could. Give that time. You want to keep interrupting me? You go right ahead. And then you did nothing. And then you come before this court. You know, you don't even file the monthly form. That doesn't even require you to be there. You did that 3 times out of 24 times. You did you did nothing. And then you get here And you know, the problem, you then try to blame Miss Polera that she didn't call you back. First of all, in the years that I've worked with Miss Polera, that doesn't happen. You tried to call out and tried to blame the wrong person.
Right.
Anything else, Ken?
Nothing further.
Defendant is remanded to serve 365 days Washtenaw County Jail. I'm ordering that the defendant report to the Washtenaw County Jail by 6 p.m. today. Failure to report will result in a bench warrant. That bench warrant will issue without bond.
I don't have any way to
While
get
in,
to Washtenaw
ma'am, you
County.
want to keep interrupting me?
I'm sorry, sir.
While in jail, the defendant is to complete the in-jail MRT program. I will consider early release upon completion. I will waive the remaining terms, accept the financial obligations, discharge the defendant from probation without improvement. And if you want to believe that I won't issue that warrant, ma'am, try me. Thank you.
Judge Simpson, how would I supposed to get down there at 6 p.m. with no transportation?
Court calls the case, People versus Jeremiah Stanley.
There's a public defender, Laura Perry, on behalf of Mr. Stanley. Laura, do you have your statement for record?
You have them or no?
Can you hear me now?
Yes, I can hear you.
Your Honor,
I need a camera.
I've tried to turn it on. I don't know how. Things have
Well,
changed.
that you were upset about having to wait, so now we have to wait until you can turn your camera on.
Can you see me now?
Amazing how that works. Miss,
Yeah, it just gave me an option, sir.
Your Honor, I did review probation's recommendation regarding the violation. We do ask that you adopt the recommendation. Mr. Stanley and I conversation about maybe some week. He says he's going to work on that as soon as possible. He is going to provide Ms. Blair with his work authorization or work proof. And again, we ask that you adopt that recommendation today. And we did talk about the wait. He is very concerned because he's at work right now.
I'm sorry that my life happens to have emergencies. I'm on the bench every day. And if you think for him, I'm going to leave my daughter out on the side of a highway, not going to happen.
I'm sorry, sir. I totally understand it. I had a friend of myself. I had a friend of myself commit suicide this morning. I've had a very difficult morning, and I'm.
Ms. Polera, what did you want to tell the court?
Your Honor, I just wanted to provide to the court that Mr. Stanley is in violation of the terms that was ordered by the court. Probation would ask that the court give Mr. Stanley a chance to complete probation terms, and it's recommending that he serve 3 days in jail, credit for the 3 days that he served, that the balance of his $975 be paid by the application of his bond that he posted, that the court extend the prosecutor deferred for a period of 9 months, that he report to probation tomorrow at 11:30 a.m. in person, then as directed, that he become compliant with all previously ordered terms of this court within 30 days, with a final review hearing February 12, 2025 at 9 a.m.
Sir, anything you want to say before I impose sentence?
I agreed to give over the bond money to pay for the fines. That was the money I was saving up. I'm sorry that I failed to comply with the fingerprints and the outpatient therapy and everything else. I want to keep my job and not go to jail and lose it possibly.
Sentence of the court, 3 days Washington County Jail, credit for the 3 days that he served for the violations to date. He's to pay $975 or $975 balance today. I will apply the bond, which will account for 900 of that. The balance has to be paid today. I will extend his prosecutor deferred sentence for a period of 9 months. I'll order that the defendant is to report to probation on Thursday, May 9th at 11:30 a.m. in person and then report as directed. He is to become compliant with all previous ordered terms within 30 days. I will schedule a final review hearing on February 12th, 2025, 9 a.m.
Sir, is there any way that I can show up tomorrow to pay the remainder?
Fine. Pay it tomorrow.
All right, thank you, sir.
Are we done? Thank you.
Yes, sir.
Court calls case People versus Tanya Jimmers. Thank you for showing up. All right.
There on behalf of probation, Your Honor, Ms. Jimerson is before the court for hearing on both cases. Since I have provided the recommendation to the court, I did have a chance to talk further with Ms. Jimerson. Ms. Jimerson just did start a job. She's completed all of the terms, accepting the money. I've been trying to work with her with that. She doesn't have the $50 on each case that I recommended today, but she indicates that she can pay that by this Friday. She'll get her check tomorrow.
Well, let me ask you this. So she's done everything except that.
It's the money, Your Honor,
Okay.
with both. And in both cases, I was asking to extend her probation to give her a chance to do that on each case, so she can get things with an extension of 4 months on each case.
That is what we discussed, Your Honor. Ms. Jimerson did represent to me that she would have the money by the end of this week to pay. And I do know she is in compliance otherwise outside of financial obligations. So we are asking that the court adopt probation's recommendation.
I will share with the court. Ms. Jimerson can talk to you about it further. Ms. Jimerson has been experiencing issues with homelessness. So that's part of the struggle. I think that she's been staying with friends, but she has got herself working finally. So I would just like the court to be aware of that.
Ms. Jimerson, anything you want to tell me?
Hold on, but I'm trying.
You're-
And I know I was in your courtroom last month for this type of situation. So I'm trying. I had to change my job. So.
Oh, because of that situation? Okay. And Ms. Polaris said you've been experiencing years homelessness. What happened?
So I still live where I stay right now, but it's very tough because of the job situation. I was in your court last time. That's another.
These were just her probation things, right? It's a straight probation.
Yes.
And you can pay what? And you're keeping your rent straight? Are you sure? Why do I not believe you?
Yes. No, I'm not being honest.
On both of these cases, here's what we'll do, Ms. Jimerson. You show back up here, then I'll remember this, but I'm going to waive all the remaining fines and costs and discharge her from probation. Pardon? I know you do. Okay. Court calls the case, People versus Damon Watson.
Good afternoon, Assistant Public Defender Laura Kirby on behalf of Mr. Watson. I don't believe Mr. Watson is present. A good role here. I don't actually understand your Honor and ask for the
Please declare on behalf of probation, Your Honor, given that Mr. Watson should go to court for a violation of probation and not comply with the terms of the court, probation is required.
Bench warrant will issue for defendant's failure to appear, bond 10,000, 10%. That warrant will issue immediately. Court calls the case, People versus Samuel Hamilton.
Good afternoon, Assistant Public Defender Laura Kirby on behalf of Mr. Hamilton. Mr. Hamilton, can you unmute and state your name for the record?
You're just having a great day.
Happy to be here. However, this week was just yesterday. I don't know why he's not here and asked for the
Bench warrant will issue bond 10,000, 10%. And warrant will issue immediately. Court calls the case of the People versus Marie Offred.
Pay for Ms. Crawford, who I believe should have made a $270 payment that night.
You mean she should have paid off her balance?
Correct. She has a zero balance, Your Honor.
So it seems things are going well for Miss Page. Miss Parody, you may want to take a lesson from that. I'll cancel the show class.
Thank you.
Court calls case People versus Achla Kanarni.
Clear on behalf of probation, Your Honor, Ms. Carnati was scheduled before the court for a final review hearing on a prosecutor's deferred sentence to complete all terms as ordered by the court. I did waive for hearing probation, recommending that the court dismiss the case pursuant to the prosecutor's deferred and discharge of probation.
Hearing no objection, so ordered. Court calls case People versus Sarah Malowski.
Good afternoon.
I messed that up entirely. You were shocked you actually had a client? Oh, and she didn't even need to be
Oh
here.
my gosh, this is my only day off.
Was it? Well, thank you for spending it with us. All right, go ahead.
So, I don't think that's the law, right? This is public defendant Laura Tierney on behalf of Ms. Shalaus. Mahaski, say your name, please.
Sarah Mahaski.
All right.
Teresa Clara on behalf of probation, Your Honor, Ms. Mahaski is before the court for a final review hearing on a prosecutor's deferred sentence. Probation is recommending that.
Yeah.
Must be a good thing if I stay down.
No. All right. I will dismiss the case pursuant to the prosecutor's sentence program. Discharge you from probation with improvement, and the case closes. Good luck to you, ma'am. Take care. Enjoy the rest of your day off.